The moment you found out that the state was going to be fleeced, cancel it. But Oforiatta chose to renegotiate. Look, see how many arbitration cases we went and we won.
There was a specific charge relating to the buses. If you conspire with somebody to commit a crime, you are liable. And in all or most of these things, you will be charged just like the person who committed the crime or did the crime. What we must let everybody understand is that.
Look at the famous ones. Some involving billions of Ghana cedis, even internationally. We canceled the contracts and we won.
All right, abusunya ya sense wa share bi me share say dia na ensem no de ko ene de ba ni na ene etrase edi ehun enkomo na abusunya ensem na ekoso ensem bebre ekoso amanfo echi o madwene ende key point aye de ka se fa be woso lawyer Martin Kpebu Kofi Bentil Professor Jampo abusunya omo yina eklashe ye na chese ensem ne de this week ne de ekoso ene de ba ye ni na no obia eche na adwen e wo ho abusua na enye fe dia dro na chese insam no ye ba betie de obia e kan ye e fa eye Sedinam Tamakloe ne ho sensem no obia eche na adwen e wo ho e ha eye Ghana Politics TV mesro and then your first time I need you obe subscribe na wa share amam uwie so don't forget o comment no e ho ehia pa chese wa adwen e wo comment section won so Mamme, enti abusuan ye ba eye Sedinam Tamakloe ne ho sensem maslock e ho sensem abusuan sika ekoye ene kasa ejeda ye ni nyina no e ho sensem a je se ye maami amanfo echiremu a onkoda ni bre ho after se oba Ghana no yes say ne ho sembia eni ho enti yenja maami na onkotena ne fie watch ne no e na atoni January e de ba ye say no judgment na ba ye no ono mo enya adwen into be san so eden akwa appeal na ende lawyer Martin Kpebu echiremu a on de hu mistake bia e wo judgment na ba ye no ho hu mistake bia because eye finance minister former finance minister eye Ken Ofoliatta onu mompo na wo sanka aban etwe na so because oba ye no one maame no eye renegotiation a chese se ne kata mu ya se bibi e wo mu a adentina Ken Ofoliatta eye den ene maame no ekwakoye renegotiation a chese abusunya sa ensem no na lawyer Martin Kpebu ne ensem no okan no menye lawyer ni but me tie de okan na eto asomu because obi a ese wa bon man no kro no adentina oba ye no one no eye renegotiation abusunya sa ensem we a eye lawyer Martin Kpebu be kan ye no Kofi Bentil ono so oba be clash on that akeka ensem bi e wo ho na menkasa bebebe no yentie lawyer Martin Kpebu emra ye wi a de Kofi Bentil so e kan ye no me da be so na wate de eden eko yenkotie emra.
The understanding that he didn't have because of the perspective that he was coming from, the logic of it, that if you sign a contract and no payments were made, there was a detection of something wrong with that contract. And as a result, renegotiated. That's the burden and then payment made. Even though in the first instance, the inflated contract as identified, no payments were made. Does the burden of the wrongdoing still rest on the person who signed the initial contract that payments were not made?
It doesn't. It doesn't rest on that person because you see, they said, the moment you found out that there were misrepresentations, mistakes, or any other things that make you illegality, so many reasons, that make the contract subject to cancellation, you had good grounds. Cancel it. Cancel it. The moment you found out that the state was going to be fleeced, cancel it. But Oforiatta chose to renegotiate. Look, see how many arbitration cases we went and we won. Look at the famous ones. Some involving billions of Ghana cedis, even internationally. We canceled the contracts and we won. If we had gone to arbitration and they had held the contract and then we came to renegotiate, right, mitigated it, then we can say whatever we still lost, we will saddle Sedinam with it. But to the extent that we didn't cancel, we just renegotiated, the axe falls on Oforiate's head. Straight.
God.
Please,
My
straight.
God.
Ask Godfrey Dami, how many international arbitrations didn't we win?
My God,
And you see, we
my
forget
God,
that the
my
state
God,
has
my
enormous power.
my God.
Any businessman worth his salt, and the company still operates in Ghana, the moment you catch the businessman fleecing the state, and you tell him, my brother, please, this thing is way overboard. We will give you what is reasonable. If you know what is good for you, any businessman will take it and walk so that he gets to do business with you. You chose not to cancel, okay, or do what you think is the proper price, but you renegotiated and now seek to saddle her with the excess. That is wrong. It is wrong. So it's definitely on Oforiate's head. That incestuous relationship and the renegotiation. The part I'm interested in, Edudzi, you know the case better than us. Edudzi, that record, the part I'm most interested in is that the people who came to do renegotiation with Oforiate, it was Kpebu Edudzi's law firm. You know that. That is what is that part that irks me. Is that part that I'm most interested in? Incestuous relationship. Very incestuous. Kpebu Edudzi negotiating with Oforiate. Kpebu Edudzi negotiating with Oforiate.
I've been a very good boy.
Oh, come on.
No.
Are we kids? Are we kids?
Is that negotiation?
That's why I'm most interested in Oforiate negotiating with Kpebu Edudzi.
Okay, so
Credibility.
Thank you, gentlemen.
Credibility.
On the matter of the Article 19 that he references.
Credibility.
No.
yes, so I
that's it.
want to respond to
quickly.
the Article
No, Mr. Bentil.
19.1, Article 19.1
He didn't answer my question.
that I referenced above. You see, if you look at the Constitution, it says that a person be informed immediately in the language he understands in detail of the nature of the offense charged. This particular provision was picked from the 1960 Constitution as well. And so many years ago, our superior courts have had a benefit of going
That's not
through.
what you said.
Oh,
You quoted 19.1d to disprove the
yes,
superiority
yes.
of 31.2.
No, so that is what I'm coming. Oh,
But then what you
relax.
read there does not go to it.
No, your position was that a defect can be cured because the provision you referenced, 33.1.2, can cure that, and that you have to go for what? A retrial or something. And I'm saying that that provision, in the face of the 1992 Constitution, Article 19.1d, it does not make any sense because this is what the Supreme Court said. Reference that provision. And again, I want to refer to the reasoning of my Lord Justice Kpebu. And if you look at the decision of Osei Kudjo II and the Republic, Criminal Appeal Number 2, 2000, delivered on the 11th of July, 2008. This is what he says. Because of the view I hold on the issue of defective charge sheets, where the particulars are defective, I need not examine cases like Andor and the Republic, the State versus Kpebu, the lines of cases on defective charges. I say so because I fully endorse the progressive views of Heffron Benjamin, J, expressed in the case of the Osei and the Republic, where the learned judge held that clause, Article 20, Clause 2 of the Constitution 1969 requires that every person charged with a criminal offense be informed immediately in a language he understands and in detail of the nature of the offense charged. The nature of the offense, an omission of an essential ingredient in the particulars of offense sin against the Constitution. And a conviction based on such a charge cannot be upheld under any circumstance. This is the decision of the Supreme Court.
Okay.
The appeals court is bound by the decision of the Supreme Court. You have not offered any contrary reasoning. And you say we are not doing law. We are doing mob justice. I cannot associate with that poverty. I cannot associate it with a situation destitute of law. and logic on the commitment. This is where it becomes even more bizarre. And I'll give you 2 examples.
Quickly.
If you recall, City and Country Waste, Kpebu, you remember?
Yes.
AMA and City and Country Waste.
Yeah.
There's a company, the Anans company had a contract to do waste collection in the country. In 2001, when the NPP came to power, they said, look, Ediana got that contract without fulfilling the various procurement rules, and that the contract sinned against the Public Procurement Act at that time, and the relevance laws of this republic. The matter went right to the Supreme Court. The Supreme Court said, contracts made contrary to statutes are unenforceable. In the specific case of this, the only reason why the court asked that payment be done was based on quantum merit.
Absolutely.
Because work has been done.
Yes.
In this specific case, and if you look at the reason of the Court of Appeal, the Court of Appeal said your accusation against Sedi is that these things were done contrary to law, and for which reason you have charged her having committed a republic. She never paid anything. Now, if the thing was contrary to law, and listen to the reason of the Court of Appeal, if the thing was done contrary to law, on what basis did you, the first prosecution witness, together with the finance minister, authorize the payment? And you even come to the court as a prosecuting witness. And
that's the say first prosecution.
First prosecution witness is Sedinam. So under cross-examination, lawyer for Sedi then asked him, this contract, who did the renegotiation? And everybody knows. So when a contract is renegotiated, the renegotiated contract takes the place of the original. What it means is that the original contract is no longer relevant. So, for all intent and purpose, the contract based on which the payment was advanced was a contract negotiated by the very people prosecuting her. It didn't make logical sense.
Okay,
but
thank you.
I just want to refer something on the record. Oh, Sina, so
you would have allowed anybody else. You would have allowed
Okay,
anybody
please.
else, Alfred.
Thank you very much. So, Alfred, I have no doubt that our listeners are
What you are
confused
doing.
with all that is going on with
They are not
Edudzi.
confused.
But
They are
it's my time. I beg you. So, Alfred, if you are chief executive of a
I
company,
encourage you.
if you are chief executive of a company, and one of your officers goes to do a transaction on behalf of the company, something that should have cost 1,000 cedis, the person goes and negotiates for it to be 3,000 cedis with the intent of being paid the extra. Okay?
Intense.
Please.
Hey, senior.
Okay? Now, and execute a contract to that effect, binding the company.
Yes.
All right? And therefore, it's going to go ahead, and then you find out. When you find out, you are like, this is a crime. So, because he has bound the company, and the company can be sued, because that officer is a proper agent of the company.
Yeah.
What you do is you say, okay, dear company, don't sue. You renegotiate, take it off, and then you pay and remove your liability. But that person's crime is established. Because, hey, please, I beg. In this case, Alfred, I'm talking to you. Alfred. Let me continue. Alfred, I beg you. Tell them to keep quiet so I can continue. Okay,
You said it was illegal.
Tell them
You said there was no PPA approval.
Let me finish.
No, don't deceive us.
our
You said there's no
law, in
PPA
our law,
approval. You said the law was not followed. So you cancel it. You cancel it. If you choose to renegotiate, it's on your head.
Can you tell him to keep quiet?
No, you said there was no PPA approval, etc.
Yes.
It was an illegal contract. How do you go and renegotiate an illegal contract?
Mr. Bentil,
Please, spare us this.
I will
Spare us this. Just spare us this. It's enough of the politics. Enough of the politics. You go and sit there and do an essential relationship.
Politics you are using to clear your people. We are talking politics.
You say an illegal contract. Why don't you cancel it?
By way of
You say something is illegal. Cancel it.
Your politics
Cancel it. Why do you renegotiate an
Anytime I am talking, anytime he's talking,
Why
then there's a
negotiate an
more.
illegality?
Why?
Let me hear.
There's a more.
Hold on.
Why?
Hold on. Mr. Bentil.
One person.
You and
I maintain
Whatever you do, he will still
save
speak.
energy.
So, hold on.
I maintain everything I said. In our act, our Act 29, dear listeners, there is something called inchoate offenses. Crimes that are committed and are not
She was
completed.
not charged for anything.
Exactly.
Hold on.
Are you now going to refile charges?
We are filing charges. Wasn't the charge?
Thank you.
It's not everything you should try to spin.
The charge against Eddie was not
We are not
anything.
finished. When is your turn?
I
You
would rather say that to you
We are not
because you are
finished.
trying to make us believe that the state has not lost resources.
He's not
The state has lost
You
resources.
had the opportunity to cancel it and you chose to go and
You need the opportunity to cancel it. How
Exactly.
can you cancel it?
Hey, I needed that contract. That was
No,
your
it
word.
was not illegal.
That's what you said.
The reference you made to statute is not the same thing here.
It is.
It is not.
You don't even know the charge. What was the charge?
Okay,
What was the
both
charge?
of you are not being heard.
What was the
Public
charge?
You are not being
procurement.
heard. Thank you. Mr. Bentil, I want you to.
In our laws, Act 29, there are crimes that are called inchoate offenses. Which means you set out to commit the crime and you sufficiently get to the point where you can be charged for it. An attempt to commit a certain crime in Act 29, in our law, attempt, if you sufficiently proceed, it can be held against you and you'll be charged. A preparation to commit a crime constitutes an offense that you can be held for. Okay? If you abet a crime, somebody is committing it and you help it, okay, you are liable. If you conspire with somebody to commit a crime, you are liable. And in all or most of these things, you will be charged just like the person who completed the crime or did the crime. What we must let everybody understand is that many times our government officials, the thieves in power, go and do all these deals with the intent of kickbacks or later on getting whatever it is and all those things. Now, when government changes hands, then we see the length of that frog. Many people, okay, would have gone to the point. Today, the present minister is doing something which I like. He's asking all the chief executives to seek appointment before they commit the government.
That's a commitment authorization.
Yes. Do you know why? Because no matter how bad the deal is, when you commit the government, the government has to pay.
Was that the law there?
I beg, please.
That's why he
So
amended the
what
Procurement
everybody
Act.
must understand is this. If a public official proceeds to commit a crime but does not finish, there are situations where that crime can be held against that person. They will be charged, accused, tried, jailed for that reason. So please, all the plenty talking that we are dealing with, okay, we need to situate it. If indeed she didn't commit the crime, she didn't go and buy things at 3, 4, 5 the price, and we did not have to pay, it would be very easy to cancel it, and I think that would have been done. The reason why it is renegotiated is because it is not easy to cancel, so you renegotiate it to lessen the incidence on the states. Thank you.
And assuming that
They should read Act 29.
So the people watching you this morning,
They should read. I'll give you the sections. Do you want the sections?
are very informed.
Act 29. Read
Now,
section
you see,
19.
you see,
I can
Read
open it.
sections 20 and
I'll access
22
it.
for abetment.
You should
Read sections 23.
When he's making a point, he wants to
From
move
section
on.
19 all the way down. In fact,
Alfred,
start from section
Alfred,
18.
Energy,
Act 29 from section 18 all the way to 25.
Okay.
Done.
You will see
Now,
inchoate
Alfred,
offenses there.
let me come in. You see, we are not permitted to misinform people.
When I'm quoting the law.
We are not permitted. There was a specific charge relating to the buses. Count 79. Particulars of offense.
That should be 78 because
Yes,
of the mistake.
exactly.
So you are
So they
making
say, no, this is it.
Yes.
It says, contravention of Procurement Act, contrary to section 92(1) and 41 of the Procurement Act, that you procure the supply without satisfying the prescribed conditions. This is the charge. No intent, no inchoate offense, substantive offense. And lawyer, you sit here and mislead the public.
What did
Now
I
you
say
can
which is wrong?
substitute an ingrate
Tell
of
me
faith
one
for
thing I
substance.
said which
Is that
was
the
wrong.
learning you have received?
Tell me one thing I said which was
Gentlemen,
wrong. I said
thank you.
our
Now,
law.
look,
When you
thank
talk
you very
about
much.
somebody
Do
renegotiating
better.
something, so
Do
it's not
better.
that.
Now,
It's not-
we will wait for how
I mean,
this
you are
appeal
desecrating
will
the law.
Proceed.
This
Thank you.
appeal is a ruse.
All right.
That appeal
There
is
are
a
a number
ruse.
of people
It's
who
a
have sent
ruse.
messages.
It's a face-saving
responding to
ruse.
Some of, in fact, some of the questions asked in the message.
I think I've come to the conclusion that you guys lost the election because
Thank you,
of
gentlemen.
Sedinam.
Hold on. This one says, Dr. Kumsin says, good morning. Greetings to the panel. It's sad how politicians and political actors have managed to make truth subjective in this country. You say, this Dr. Kumsin from UCC. This one here from Professor Stephen Kwekwasare. Good morning. And I
Hey, Prof.
reference his summary of this case, which I referenced earlier, and he's watching us right now. It says, this is not the first time the Court of Appeal has set aside a criminal case because the trial court improperly shifted to the accused
forcing
the
they say,
burden
and they
of
say
proving a negative that the law requires the prosecution to prove. Where the prosecution alleges that an accused acted without authorization, it is for the prosecution, not the accused, to prove the absence of authorization. That recurring error underscores the need for continual judicial and prosecutorial training in the law of evidence, particularly on the allocation of legal and evidential burdens. I think Mr. Bentil referenced that about the quality of
Or the
our
prosecution.
prosecution. It's
On
important.
both sides.
Yes, okay.
You want
Thank you.
equalization.
Gentlemen, let me finish. Please. Koku Abochi also says, PW1 evidence further confirmed that the appellant did not authorize payment for the 350 vehicles during her tenure as Chief Executive Officer of Maslock. It was PW1, that is in this case, Dr. Stephen Amwa, who, after assuming office,
Maybe now
and
the state can take
renegotiating-
an action against Tika.
Let
Maybe.
me finish. Renegotiating the unit price in 2017, authorized payments to Mark Autos. Those payments continued in 2018, by which time the appellant no longer held office. If, as the prosecution suggested, the contract lacked the necessary approval or ministerial authorization, it is difficult to see how Stika, that is Dr. Stephen Amwa, could lawfully have proceeded to perform it and authorize payment under it. Thank you. This one also, Adam Senanu, good morning. He says that I don't see politics laced in this. We must wait to see how this appeal will proceed. We are all watching with keen interest. Thank you. Let's go on to the next issue.
Just one sentence. Look at what the judge said. Look, paragraph 117. It says that, Ahiagba, it says that if, as the prosecution suggested, the contract lacked the necessary approval or ministerial authorization, it is difficult to see how PW1, that's Dr. Stephen Amwa Stika, could lawfully have proceeded to perform it and authorize payments.
That's what I actually just read.
The prosecution therefore failed to prove.
That's what
you
I
said
just
that
read.
it lacked authorization, it's illegal,
Lawyer Martin,
and you are
that's
paying.
what I just read.
Now, rather
this is key point.
we are live.